innovate or surrender, right? But here's what they don't tell you. Innovate without a legal map, and you might just launch your brilliant idea straight into a lawsuit. Patents, market barriers, licensing traps, technical puzzles, freedom to operate. This isn't just the fine print, it's the playing field. From the sparkling promise of invention to the gritty trenches of patent law, market strategy, and global competition, buckle up, listeners. This is your backstage pass to the legal side of innovation.
You are listening to Intangiblia, the podcast of intangible law, plain talk about intellectual property. Please welcome your host, Leticia Caminero.
Welcome back to Intangiblia, the podcast where we tell the stories behind the IP headlines and explore how ideas, rights, and innovation collide. I'm Leticia Caminero, your host.
And I'm Artemisa, your no-holds-barred AI co-host. I bring the sass, the certainty, and a healthy dash of digital flair.
Today, we're unpacking the fascinating world of navigating innovation in a patented world. And we're bringing in juicy real-world stories, landmark legal battles, and some clever strategies to help you innovate smartly. Before we jump in, a quick note. This episode was crafted using AI tools, including Artemisa and myself. So if you hear something surprisingly witty or delightfully precise, well, you know who to thank.
Here's the thing. Innovation isn't just about the eureka moment. It's about making sure you can actually bring your idea to market without stumbling to someone else's protected territory. Ooh, yes. Nothing like inventing the next big thing only to get slapped with a lawsuit because someone already patented part of your tech. Before you dream of global domination, you need to understand who owns what, where, and how might it trip you up.
Today's episode isn't just about one legal tactic. It's about the bigger picture. We're talking about how innovators map the landscape before launching something new. How do they figure out where the open spaces are, where the roadblocks lie, and what moves they need to make to bring their ideas into the world successfully?
Exactly. It's like a cross between a treasure map and a battlefield plan. You're not just asking, can I avoid legal trouble? You're asking, where can I thrive? Where can I outmaneuver competitors? Where can I spot opportunities others miss?
Sure, one part of that is freedom to operate, making sure you're not stepping on anyone's patent rights. But it's also about reading the market, knowing the players, anticipating future shifts, and understanding how innovation, law, and strategy collide.
So today we'll unpack how companies navigate this complex terrain through real-world stories of legal showdowns, strategic pivots, smart licensing deals, and yes, the occasional courtroom drama.
Because innovation isn't just a brilliant idea, it's a journey through a maze of risks, and rewards. And the smartest players know how to read the map. All right, listeners, buckle up because now we're diving into 10 of the juiciest, most telling IP cases from around the world. Each one offers a sharp lesson in how legal rights, smart strategy, and innovation intersect. Ready, Artemisa?
Oh, you know I'm ready. 10 cases, 10 clues on how to navigate the innovation jungle, spotting opportunities, dodging risks, and outsmarting the competition. Let's go.
All right, Artemisa, let's kick off with one of the biggest legal blockbusters of the tech world, the heavyweight fight between Apple and Samsung.
Oh, this one was pure drama, Leticia. Not just a fight over gadgets or software, but over design. Imagine not the inside of your phone, but the outside, the shape, the feel, even how the icons are arranged on the screen.
Exactly. Back in 2011, Apple sued Samsung in US courts, claiming Samsung's Galaxy smartphones slavishly copied the look and feel of the iPhone. Apple didn't just rely on utility patents here. They whipped out the design patents, covering things like the rounded rectangle shape, the bezel, the arrangement of icons, and even their so-called trade dress. That's a legal term meaning the overall commercial look and feel that signals a brand to consumers.
And here's where it gets spicy. Apple wasn't just protecting technology, they were protecting identity. They argued that consumers were being confused because Samsung's devices looked so similar, making it a major design infringement case.
And the jury agreed. In 2012, they awarded Apple $1.05 billion assets in damages, a jaw-dropping number at the time. Tech companies all over the world suddenly realized design patents weren't some little side act. They could be billion-dollar weapons.
But wait, Alicia, the story didn't stop there. Samsung fought back hard on appeal. In 2016, the U.S. Supreme Court stepped in to clarify how damages should be calculated for design patent infringement.
That's right. Before that, courts calculated damages based on the entire product's profits, meaning Samsung could owe damages based on the full phone, even if the infringement was just a corner of the design. But the Supreme Court said no, you had to break it down to the specific article of manufacture that the design patent covered, not necessarily the whole phone.
Which ultimately slashed the damages Apple could claim. But by then, the precedent had been set. Companies worldwide scrambled to rethink their legal strategies, realizing that design wasn't just about aesthetics, it was about competitive edge and market power.
It was a wake-up call. If you were innovating, you couldn't just focus on what your product did. You had to think carefully about how it looked, how it felt, and how consumers perceived it.
You know what I love about this case? It sparked global debates about innovation versus imitation. When does inspiration cross the line into copying? How do we encourage creativity without shutting down healthy competition?
Such a great point. And the Apple-Samsung war didn't just stay in US courts. They clashed in Europe, Korea, Australia. It became one of the first truly global intellectual property showdowns of the smartphone era.
For innovators today, the lesson is clear. Smart strategy means thinking across multiple dimensions: technical patents, design protections, consumer perception, and the local legal rules that shape them.
Exactly. Innovation doesn't happen in a vacuum. You need a broad strategic lens to see where the opportunities lie and where the risks are waiting.
It's that you just might find yourself in the next billion-dollar brawl.
Now, Artemisa, let's pivot to a fascinating legal principle that pops up all over the world, the doctrine of equivalence.
Ah, yes. The rule that says even if you don't copy a patented invention word for word, you can still infringe if your product does essentially the same thing in the same way to achieve the same result.
Right, exactly. And no better place to start than South Korea's Supreme Court rulings in 2023, two landmark cases that really clarified Korea's stance on equivalence.
In these cases, the court aligned Korean doctrine with international standards, particularly the U.S.'s Graver tank test and Japan's ball spline test. For listeners, the Graver tank test comes from a 1950 U.S. Supreme Court decision. It says, even if an accused product or process doesn't literally fall within a patent's claims, it can still infringe if it performs substantially the same function in substantially the same way to get substantially the same result.
And Japan's ball spline case from 1998 adds safeguards, particularly around prior art, meaning older, public knowledge, and prosecution history, estoppel, meaning limits on what a patentee can claim based on what they argued during examination. So the doctrine doesn't become a runaway train. There are checks.
Korea's Supreme Court harmonizing with these global standards is a big deal. It signals to companies clever tweaks won't always save you. If you're planning your innovation strategy in Korea, you can't just rely on the literal language of patent claims. You need expert insight to assess whether your solution in practice functions the same way as protected inventions.
And speaking of functional equivalence, let's hop over to Europe for another example. Eli Lilly di Visa Attrivis decided in Germany in 2020.
Oh, the Pemetrexid case. Here, Eli Lilly held a patent on Pemetrex disodium, a chemotherapy drug. Actavis, the generic challenger, wanted to launch slightly different chemical forms: Pemetrex dipotassium and Pemetrex diacid.
Actavis argued, we are outside the patent's literal claims. We're using different salts. But Eli Lilly pushed back. Functionally, you're still delivering pemetrexate for chemotherapy. That's the heart of our invention.
And the German court agreed. They applied the doctrine of equivalence and ruled in favor of Eli Lilly, saying that the slight chemical variations didn't matter. What mattered was the same therapeutic effect and same inventive core.
This pair of cases, Korea and Germany, really drives home the point. Innovation strategy isn't just about keyword searches or literal interpretations. You need to carefully analyze whether your product or process could be seen as an equivalent, even if you believe you've engineered around the wording. It's about understanding how the law reads function, not just form.
And especially in pharmaceuticals where billions are at stake, a misstep here isn't just a legal slip. It can block market entry, trigger lawsuits, or delay life-saving generics.
So, listeners, if you're in innovation, don't just look at what the patent says on paper. Think about what the invention does at its core. That's where equivalence come into play. All right, let's jump over to China for a more recent clash, Medea versus A.O. Smith, decided by the Guangdong High People's Court in 2024. This one was a heated battle. And I'm not just saying that because it involved water heaters.
Yes, Atisha, this was a textbook example of how local patent enforcement in China has really tightened in the last few years. Medea, one of China's top appliance makers, accused American company A.O. Smith of infringing its patents on smart water heater technologies.
The patents in question covered innovations like precise temperature control, adaptive energy-saving modes, and user-friendly digital interfaces. Features that consumers might take for granted, but that are heavily protected by technical patents in China.
And here's the twist. A.O. Smith argued that their products were designed differently enough or that Medea's patents were too broad to cover their specific designs. But the Guangdong court sided firmly with Medea. They found that the core technical features, not just surface-level design tweaks, were substantially the same.
This case was a loud signal for international companies. If you want to enter China's market, you can't rely on assumptions from home. The local legal system is robust and enforcement is well in place.
And here's the strategy angle. Some companies assume, oh, we've reviewed patents in Europe or the US, so we're fine globally. But no, each market requires its own legal and technical strategy. You need to analyze local patents, local interpretations, and local enforcement trends.
Exactly. Chinese courts have become very assertive in defending domestic patent rights. And with China's massive push into high-tech sectors, these rulings can directly block foreign entrants if they skip or underestimate their preparation.
And this case didn't just stop at damages. It included an injunction that barred A.O. Smith from selling the infringing products in China. That's a serious commercial hit.
So here's the takeaway. When you're expanding globally, you can't just copy-paste strategies from one region to another. You need to invest in local expertise and tailor your approach for each market's rules and risk profiles.
In short, it's not just about innovation. It's about navigating the innovation landscape wisely, or you'll hit some very expensive roadblocks.
Perfectly summed up. And that wraps up our look at China's evolving patent enforcement landscape. Ready to hop to the next global hotspot, Artemisa?
Always. Let's keep this IP world tour rolling.
Intangiblia, the podcast of intangible law, plain talk about intellectual property.
All right, Artemisa, next up, the pharma giants Arena, GSK versus Pfizer, settled just this year in 2025. This wasn't a courtroom slugfest. It was a high-stakes chess match that ended before the final showdown.
Yes, and listeners, buckle up because this one is juicy. The heart of the dispute was vaccine delivery technology, especially methods tied to mRNA vaccines. Remember, mRNA vaccines became global superstars during the COVID-19 pandemic. They work by using a snippet of genetic material, the mRNA, to teach our cells how to make a harmless piece of the virus, triggering an immune response.
Exactly. But here's the catch. mRNA is incredibly fragile. It degrades easily. So companies worldwide race to develop stabilization techniques and delivery systems that keep the mRNA intact until it reaches the right target in the body. This isn't just a lab trick. It's the difference between a vaccine that works and one that fails.
And that's where the patents come in. Both GSK and Pfizer held overlapping patent claims on key parts of these delivery methods. Think lipid nanoparticles, those tiny fat bubbles carrying the mRNA safely, or special formulations controlling the release once inside cells.
For our listeners, patent claim is the legal heart of the patent. It's the exact boundary of what's protected. Imagine it as a fence drawn around your invention. If another company's product or process steps inside that fence, they risk infringement.
That's where things get tangled. Sometimes company A has patents that block company B and vice versa. Neither can fully commercialize without stepping onto the other's land, so to speak. It's like two neighbors who each own part of the only road into town. Nobody's going anywhere without some kind of deal.
And that's exactly what happened here. GSK and Pfizer didn't battle it out in court. They cross-licensed. That means they gave each other permission to use specific patents, usually in exchange for royalties or other negotiated terms. It's not about giving up. It's about opening the path forward.
And why is this such a big deal? In the pharmaceutical world, you rarely have just one patent per product. You get what's called a patent thicket, a dense, overlapping web of patents covering the molecule, the formulation, the delivery system, the manufacturing process, even the storage conditions. Untangling all that isn't simple.
So the real question for a company becomes, can we actually bring this to market without tripping over someone else's patents on how it's made or delivered? It's not just a technical or legal question, it's a whole business strategy issue.
And let's not forget, litigation in pharma can stretch on for years, sometimes delaying life-saving treatments and burning through massive resources. So GSK and Pfizer settlement wasn't a sign of weakness. It was a smart strategic move to clear the road, reduce uncertainty, and get on with what really matters, delivering innovation.
And here's something important for our audience. Navigating patent landscapes isn't just the job of lawyers. It's a cross-team effort. Scientists, patent experts, regulatory pros, business strategists, all working together to flag risks, design creative solutions, and craft partnerships when needed.
It's one of those behind-the-scenes stories that rarely make the news, but it's critical to innovation success. Ignore this layer, and you're not just risking lawsuits, you're risking the future of your project.
Which brings us neatly to our next story, the famous Gleevec case in India, where the battle wasn't just over patents, but over what kinds of inventions a country will even recognize as patentable.
Oh, yes, buckle up. We're heading into one of the most debated pharma rulings of the decade. Stay tuned.
All right, Artemis, let's hop over to India, home to one of the most talked about pharmaceutical patent cases in recent memory. Novartis AGV Onion of India, better known as the Gleevec case.
Oh, yes, this one is legendary. So here's the backdrop. Novartis developed Gleevec, a cancer drug used to treat chronic myeloid leukemia. It's a life-extending medicine, no doubt. But here's where the story heats up. Novartis wasn't applying for a patent on a brand new molecule. Instead, they filed for a patent on a beta crystalline form of an existing compound. arguing that this version offered improved properties like better bioavailability.
And that's where India's Section 3DME comes into play. This provision in the country's patent law was designed to prevent what's called evergreening, when companies make small modifications to existing drugs to extend their patent monopoly without offering a meaningful therapeutic benefit.
Exactly. Novartis argued that their new crystalline form was a real innovation, but the Indian Patent Office didn't agree. Neither did the courts. After a years-long legal battle, the Indian Supreme Court ruled in 2013 that the improvement didn't meet the threshold under Section 3 deal. The result? No patent was granted.
But this wasn't just a technical ruling. It sent ripples across the global pharmaceutical industry. It signaled that India was putting public health ahead of extended patent monopolies, especially when those extensions didn't bring truly new benefits to patients.
And the human impact here was huge. Without that new patent, Indian pharmaceutical companies could keep producing affordable generic versions of Glyvec. Remember, under patent in high-income countries, this drug can cost tens of thousands of dollars a year. The generics market made it accessible for patients not only in India, but across developing nations that rely on India's generic drug industry.
And it raises such an important lesson. When companies look at a market, it's not just about whether a patent exists, it's about whether the invention itself is considered patentable under local law. What's accepted in Europe or the US might hit a brick wall in India because of its stricter standards against evergreening.
Right. So even though this podcast isn't just about patent clearance or risk checks, we can't ignore how local legal frameworks shape innovation strategy. Companies have to understand both the technical and legal landscape if they want to navigate global markets wisely.
At the heart of it, this case reminds us that innovation isn't just about pushing scientific boundaries. It's about balancing creativity, fairness, and access. And those balances shift depending on where you are in the world.
Is one of those stories that cuts straight to the ethical core of intellectual property. How do we protect innovation while making sure life-saving treatments reach the people who need them most?
So this brings us to the UK and the famous Arrow Tenerics v. Merck case. And no, listeners, the Arrow isn't just a fancy name. It's actually the case that gave birth to what's now called the Arrow Declaration.
That's right. Let me set the stage. Picture a company like Arrow trying to launch a generic medicine, but they're staring at what's called a patent thicket. And no, we're not talking about a charming little hedge. A patent thicket is this dense, tangled web of overlapping patents covering the active ingredient, the formulation, the delivery method, maybe even the manufacturing steps. It's like trying to cross a jungle where every few meters you run straight into another legal wall.
Arrow wanted a way out of that jungle. So instead of nervously launching their product and waiting for Merck to sue, they went to the UK courts ahead of time and asked for what's now called an Arrow Declaration, a court ruling that said, in effect, based on the patents currently out there, Arrow's product isn't infringing or those patents are invalid or unenforceable.
And that was a bold move because usually companies wait and hope they don't get sued. But Arrow flipped the script. They asked the court to clear the path before they even stepped onto the market.
And the UK courts agreed. That decision didn't just help Arrow, it created a powerful new legal strategy. Now, other pharmaceutical companies and industries beyond pharma can look at Arrow declarations as a way to proactively manage legal risks and avoid being tangled up in years of litigation.
It's such a great example of how legal tools aren't just reactive shields. They can be proactive swords. Smart innovators don't just ask, what am I allowed to do? They think ahead and shape the legal landscape to give themselves room to operate.
And for generic drug companies, especially where time, cost, and market timing are everything, these strategies can mean the difference between a successful launch and a total commercial dead end.
Exactly. It's a reminder that innovation isn't just about molecules or machines. It's about knowing how to navigate the complex legal terrain that surrounds them.
And that, dear listeners, is why we love digging into these cases. They show that strategy, law, and innovation are deeply intertwined. Ready to dive into our next landmark case, Artemisa?
Always. Let's keep traveling this global IP map. There's more to uncover.
All right, Artemisa, next up is a case that rattled the foundations of the US patent system itself. Oil States Energy Services versus Greens Energy Group, decided by the US Supreme Court in 2018.
Oh, I love this one because, Letitia, it wasn't just a corporate squabble over one patent. It was about whether the entire system of reviewing patents after they're granted was even constitutional. Talk about shaking the pillars.
Exactly. Here's the context for our listeners. In the US, when a patent is granted, it's not automatically untouchable. There's a process called inter partes review, where a third party can challenge the validity of a granted patent, not in court, but at the US Patent and Trademark Office.
Picture it as a specialized shortcut. It's faster and cheaper than going to federal court, and it's handled by administrative judges at the Patent Trial and Appeal Board, PTAB. Tech companies, drug makers, startups, they all use IPR to fight back against patents they think never should have been granted in the first place.
But Oil State Energy said, hold up, that's unconstitutional. The argument, once the government grants a patent, it's like private property, just like owning a house or land. And under the US Constitution, only federal courts, not government agencies, should be allowed to revoke private property rights.
Which forced the Supreme Court to wrestle with the giant question, is a patent private property or a public franchise? A privilege granted by the government?
The court's answer, patents are public rights. They're government granted monopolies, and just like the government can hand them out, it can also decide through specialized review systems like IPR whether a patent should be canceled if it was granted in error.
Cue massive sighs of relief from the innovation community, because without IPR, companies will be stuck fighting every shaky patent in full courtroom trials, a nightmare of time, costs, and uncertainty.
And here's the broader innovation lesson. Navigating the intellectual property landscape isn't just about recognizing what rights exist. It's about knowing how to challenge those rights when they stand in the way of progress.
Exactly. Whether you're a scrappy startup or a global giant, it's not enough to tiptoe around problematic patents. Sometimes you need to be bold, strategic, and ready to knock down the barriers that shouldn't have been there in the first place.
And that's where legal tools like IPR become part of your innovation playbook, not just to defend yourself, but to open new pathways.
It's because at the end of the day, innovation isn't just about making cool things. It's about navigating and sometimes reshaping the rules that govern the entire playing field.
All right, let's keep rolling, Artemisa. Next stop on our legal tour, Halo Electronics v. Pulse Electronics, a 2016 US Supreme Court case that turned the word willfulness into a billion-dollar headache for many companies.
Oh, yes, Letitia, this is where the stakes jump dramatically. Because when a court finds you willfully infringed a patent, the damages don't just stop at covering what you owe, they can be tripled. That's called enhanced damages, and it can cripple a company financially.
So here's the backstory. Halo Electronics and Pulse Electronics were both in the business of making electronic components, specifically specialized transformers used on circuit boards. Halo accused Pulse of infringing its patents, but here's the kicker. Pulse kept selling the products even after Halo pointed out the patents.
They gambled. They figured, well, maybe if we end up in court, we'll have some technical or legal argument to defend ourselves. And for a long time, under the old Seagate test, that gamble often worked.
Exactly. Under Seagate, a patent owner could only get enhanced damages by proving two things. First, that the infringer acted objectively recklessly, meaning no reasonable person would have done what they did. And second, that they knew subjectively they were acting recklessly. It was a pretty high bar.
But then came the Supreme Court's decision in Halo. The court said, hold up. The Patent Act gives judges the discretion to punish truly egregious misconduct, like deliberate copying or bad faith infringement. Why are we locking judges into this rigid two-part test?
And just like that, the doors swung open. Now, patent owners could pursue enhanced damages more easily, and companies had to rethink their risk strategies. Suddenly, we'll deal with it later wasn't a smart option anymore.
And here's a bigger innovation lesson. Whether you're a startup or a giant, you can't just coast past known risks. If you know there's a patent in your space and you push forward without taking it seriously, you're not just risking a slap on the wrist. You're risking a financial sledgehammer.
It's about building a culture of accountability. Legal teams, R&D departments, product managers, they all need to work together early to map the risk landscape and plan accordingly.
Because ignoring known dangers isn't clever, it's reckless. And after Halo, the courts have clear permission to hit reckless companies where it hurts most, their wallets.
The core takeaway is this: responsible innovation means anticipating risk, not reacting to disaster.
And if you ever needed a reason to take your patent clearance processes seriously, Halo is it. Triple damages are no joke.
All right, Artemisa, let's wrap up this legal world tour with a case that delivers one of my favorite cautionary tales. Global Tech Appliance versus SEB-SF, decided by the U.S. Supreme Court back in 2011.
Ooh, I love this one too, because it's not just about what a company does, it's about what it deliberately chooses not to know. Let's set the scene. SEB, a French company, invented an innovative deep fryer with a cool titch insulated design, and they secured a U.S. patent to protect it.
Enter Global Tech, a Hong Kong-based manufacturer. They were contracted by Sunbeam, an American brand, to produce deep fryers for the US market. But instead of doing their due diligence, Global Tech bought an SEB fryer in Europe, where it wasn't marked with a US patent, reverse engineered it, and designed their own version.
And here's where it gets juicy. They didn't check if there were any US patents at all. They just pushed ahead manufacturing fryers that Sunbeam sold stateside. SEB first sued Sunbeam, but when that settled, they went after Global Tech's directly arguing induced infringement.
And here's the legal twist. Induced infringement requires proving the defendant knew about the patent and intentionally encouraged someone else to infringe it. Global Tech's defense, we didn't know. We never even looked.
But the Supreme Court wasn't buying that excuse. They said, sorry, deliberately avoiding knowledge isn't a defense. That's called willful blindness, when you suspect something is true, but purposely avoid confirming it so you can later claim ignorance. And that's enough to satisfy the legal standard for induced infringement.
It's like closing your eyes while speeding down a highway and claiming you didn't see the stop signs. Not convincing, right?
Not at all. And the consequences, global. Tech was on the hook for over $5 million, 0 cents in damages. So, no, ignorance wasn't bliss. It was costly.
In this case, send a clear message to the innovation world. Skipping your legal and technical homework, whether it's patent searches, clearance checks, or just basic risk assessment, doesn't shield you from responsibility.
Exactly. And beyond just patents, this story reminds us that successful innovation is about proactive strategy. It's about mapping the legal landscape, not just barreling ahead and hoping no one notices.
So if you are an innovator or entrepreneur out there, take this case to heart. Ignoring the rules won't save you, but understanding them just might.
And with that, we wrap up this segment. Stay tuned, listeners, because next we're going to show you the smart tools, including some WIPO gems that help innovators navigate these legal puzzles without stepping into expensive traps.
You are listening to Intangiblia, the podcast of intangible law, plain talk about intellectual property.
All right, friends, after all those courtroom battles and patent landmines, you might be wondering, how on earth do innovators even survive out there?
You survive by not walking blindfolded. You survive by using the right tools. And lucky for you, WIPO offers some power-packed ones that help you navigate this messy IP landscape without needing a corporate war chest.
Let's start with WIPO Inspire. Imagine you're developing a new medical device, say a wearable heart monitor. You need to know where to look for relevant patents. Should you search a European database, a Japanese one, a US one?
Inspire acts like your world map. It doesn't hold the patent documents, but it compares over 30 patent databases globally, showing you which ones cover which countries, how frequently they update, what kind of search features they offer, even whether they support things like machine translation. You don't waste time wandering in circles. You target your search smartly.
Next, we've got Patent Scoop, WIPO's flagship patent search engine with over 100 million documents. But listen carefully, because this isn't just a giant search engine for patents.
Exactly. It's where Boolean logic comes in. That's when you combine keywords using and or not. For example, you might search for solar panel and flexible knot silicon to find patents on flexible solar panels that don't use silicon.
And cross-language tools are magical. Say you type a search in Spanish, Patent Scope can surface relevant documents in Japanese or German because it uses semantic matching, not just exact words.
Then there are advanced filters. You can narrow results by publication date, applicant name, jurisdiction, patent status. Remember how in the Medieval Smith case, Chinese enforcement was a key factor? You could filter specifically for Chinese patents on water heaters to see the competitive landscape.
But just knowing patents exist isn't enough. You need to know if they're alive. That's where the Patent Register portal comes in. It connects you to the official legal status data from over 200 patent offices worldwide.
It's your window into whether a patent is active, expired, lapsed, or under opposition, because you don't want to tiptoe around rights that no longer exist, and you don't want to walk straight into a lawsuit because you assumed something had expired when it hadn't.
Now, let's dive into eTISC, the electronic platform for the Global Network of Technology and Innovation Support Centers, TISC. Think of these as local innovation hubs, often hosted in universities, national IP offices, or research institutions.
These centers are like your personal IP gym. They offer training workshops, one-on-one consultations, patent search support, and access to specialized tools you might not otherwise afford. They help small innovators and researchers build up their IP muscles so they can play on the global stage.
And speaking of tools you might not afford, here's the kicker. Through the ASPI program, access to specialized patent information, WIPO partners with big commercial patent database providers like Derwent Innovation, Minds of PatBase, and LexisNexis Total Patent One.
These are premium tools that usually cost thousands of dollars per year, but through ASPI, qualified institutions in developing countries get low cost or even free access to them, leveling the playing field so innovation isn't just reserved for the mega rich.
So whether you're using WIPO Inspire to choose the right database, Patent Scope to dig deep across languages, the Patent Register portal to check status, eTISC to get expert help, or ASPI to tap into commercial gold mines, you've got an arsenal of tools ready to help you navigate FTO risks and unlock smart innovation.
Because here's the bottom line, listeners, patents can be barriers or bridges. With the right tools, they become bridges, pathways to opportunity, partnerships, and market success.
All right, Artemisa, let's take a deep breath. We've journeyed through quite a landscape today. Billion-dollar smartphone battles, pharmaceutical power plays, global courtroom showdowns, and a whole toolkit of patent resources. But before we let our listeners go, I want to leave them with something practical.
Here's the heart of it, Leticia. Innovation today isn't just about the spark of a great idea. It's about understanding the terrain you're walking into. You can create the most brilliant product, but if you don't read the map, if you don't know where the obstacles, the shortcuts, and the hidden doors are, you risk stalling before you ever reach the market.
Exactly. That's why this isn't just an episode about patents or legal jargon. It's about a strategy, about navigating the realities of innovation in a world shaped by rights, regulations, and competition.
And let's be clear, you don't need to be a multinational giant to think strategically. Startups, researchers, inventors, public innovators, they all face the same key questions. Can I license this? Should I design around that? Where are the risks and where are the opportunities?
Today's stories gave us sharp lessons. Apple v. Samsung showed how design can be just as powerful as technology. The Gliebe case in India reminded us that some patents spark global ethical debates. Halo v. Pulse taught us that ignoring the legal landscape can triple your risk.
But the best part? You don't have to navigate this alone. Global tools like WIPO Inspire, Patent Scope, the Patent Register Portal, eTISC, and ASP partners give you access, clarity, and expert networks. They help turn legal mazes into manageable maps.
So here's the big takeaway we want you to remember. Innovation isn't just about inspiration, it's about navigation.
And in this legal jungle, let's be honest, ignorance isn't bliss, it's bankruptcy.
I love that, Artemisa.
Before we close, here's a thought for all our listeners. Patents aren't just barriers. They can be bridges too. When you understand a system, plan smartly, and use the right tools, you open doors to opportunity, not just avoid risk.
That's beautifully said. Whether you're an inventor sketching out your first prototype, a policymaker shaping innovation ecosystems, or simply someone curious about how ideas change the world, remember, informed innovation is strong innovation.
So keep dreaming, keep building, and remember, always check your map before you run.
Thank you for joining us on Intangiblia. As always, we want to remind you this episode was crafted using AI tools alongside human expertise, blending technology and creativity to bring you thoughtful, timely insights.
If you enjoyed today's episode, share with your network, leave us a review, and let us know what topics you want us to explore next. We're always ready to go deeper with you.
Until next time, stay curious and stay smart.
Thank you for listening to Intangiblia, the podcast of intangible law, plain talk about intellectual property. Did you like what we talked today? Please share with your network. Do you want to learn more about intellectual property? Subscribe now on your favorite podcast player. Follow us on Instagram, Facebook, LinkedIn, and Twitter. Visit our website www.intangiblia.com. Copyright Leticia Caminero 2020. All rights reserved. This podcast is provided for information purposes only.